Welcome everyone, this is Amer from U Counsel. Oftentimes people make assumptions about the nature of their employment relationship, and sometimes that assumption is correct, sometimes it's not. And when that assumption is not correct, a lot of people potentially lose certain rights that they would have been entitled to otherwise. And so in this lecture we'll elaborate on the difference, why the difference between these three categories, employee, independent contractor, and dependent contractor matters. And then in the next lecture we'll talk about how do you determine which category do you belong to, and then who has the ultimate say, who has the power to decide what is the specific category in your employment relationship. Before we begin, just a disclaimer that this course is not legal advice, so if you have any specific questions about your issues, you must contact your lawyer or paralegal, and if you don't know anyone directly, you can contact Law Society of Upper Canada in Ontario, and they can direct you to a lawyer or paralegal. The difference between these categories matters. Why? Because under each category you will have different rights, and under each category you will have different obligations. So let's start with employee rights. The most important, well, not the most important, but one of the important rights fall under legislative rights, which means if there is a specific legislation that applies to your circumstances, you may have rights under that. A common example in Ontario is the Employment Standards Act, which applies to every employee, every non-unionized employee. And so you have rights under Employment Standards Act. Then you have rights under common law, which is the judge-made law, and you may have rights under that. And a common example is termination notice, which we'll talk about in more detail, but that could be your right under employment, under the employee rights category. Let's talk a little bit more about the legislative right, and we'll give you some examples. But some rights are termination pay, overtime pay, public holiday, vacation, parental leave, and employment insurance benefits. If you look at the Employment Standards Act, let's go there. So Employment Standards Act, which is the legislation in Ontario for non-unionized employees, and you scroll through and you will see there are a number of parts here that provide details of the kind of rights that you as an employee are entitled to. For instance, hours of work and eating period, Part 7. Part 8 is about overtime pay. Part 10, public holiday pay, vacation with pay. Look at here, Part 14, leave of absence, and you will notice the kinds of leaves that an employee could be entitled to: pregnancy, parental, family medical, organ donor, family caregiver leave. All of these categories of leaves are available to an employee if you are considered an employee. Similarly, employment insurance benefits, you may already be familiar with some of these benefits. You could be entitled to illness benefits if you are ill, and I believe they run up to 15 weeks or so. You have employment insurance benefits in the category of pregnancy and maternity and parental leave. And then, of course, you have employment insurance benefits when you are terminated without cause, and I believe they run up to about 10 months or so, depending upon where you live. So all of these rights are available. These are legislated. Another example could be workers' compensation rights. So Workplace Safety and Insurance Act in Ontario, that covers rights for the employees who are injured at work, and then you may be entitled to those rights if you are considered an employee. Similarly, you have rights under common law, and I've given you example of termination notice, which is the most important one, because if you are entitled to termination notice, depending upon the application of certain factors, you may be entitled to as high as 24 months, or sometimes a little bit even more than that, termination or severance pay. So the common law rights are important. Employee obligations, the opposite or the other side of the coin. You have legislative obligations, as we talked about in Employment Standards Act. Hours of work is an example where you are required to work certain hours. Production environment is a common example where, as you know, or you may know that factory workers who are working on production line, they have to be on that line for a specific time, and then there is a break after a certain time period which must be provided to them, and you are required to work those hours. And then if you are required to work overtime hours, you are supposed to do that. So those are some of the obligations under legislation. Similarly, you have common law obligations. Duty of loyalty towards your employer is one obligation. Duty of confidentiality is another. And there are many more other obligations that you have if you are considered an employee. If you're not considered an employee and you are considered independent contractor, what kind of rights do you have? You have no legislative rights. So that means the Employment Standards Act that we just talked about would not apply to you if you are an independent contractor. You cannot go to the employer and say, hey, I'm entitled to 2 weeks of pay because the ESA, Employment Standards Act, says so, because you're an independent contractor. Similarly, you're not entitled to parental leave, or you're not entitled to overtime pay. You know, all of those things you're not entitled to. So what is it that you are entitled to? If you're an independent contractor, then your contract, your specific contract that you have entered into with the employer, with the company, that's what prevails. So if the contract defines what your termination rights are or your resignation obligations are, then those are your rights and those are your obligations. If you are entitled to overtime, it will be specified in that contract. And it is very unlikely that you may be entitled to overtime in independent contractor arrangement, because independent contractor, as sort of the name implies, you are quite independent of the employer or the company, and usually they have no control over the kind of hours that you will work and when you will work. Those are usually left to the independent contractor. Similarly, your wages will be defined in that contract, your vacation. So anything and everything that is put in that contract, you know, is your right. You don't have the legislative right that we went through in detail, which applies to an employee. Similarly, you have no employment insurance benefits. I mean, there are some exceptions, but please understand that by default, if you are considered an independent contractor, you will not be entitled to any employment insurance benefits. Some exceptions are, and you can look up in the Employment Insurance Act, where there are, in some cases, the independent contractor can remit certain payments for the EI and could be entitled to it, but those are exceptions. Those are not the norm. Jumping on to dependent contractor. Dependent contractor is sort of a category between the employee and the independent contractor. So what kind of rights and obligations does a dependent contractor have? Well, again, the dependent contractor has no legislative rights. So no rights under Employment Standards Act, no WSIB. With respect to common law rights, now here's where it gets interesting. A dependent contractor may be entitled to certain common law rights, and in the case of termination notice or severance, a dependent contractor may be entitled to that. So it's an important thing to note that this is a category which looks much like an independent contractor, but it's not. Again, with respect to employment insurance benefits, a dependent contractor is not entitled to it, but there are some exceptions which are similar to what an independent contractor category entails. So just talking about these categories, it is important to know which category you fall under, because then you would know what kind of rights and obligations you have. I'll give you an example. One of my clients, he had contacted me some time ago, and he was in the movie production business. He had his own company, and he worked for one specific company and provided this production services. So he will go to the location and do all the setup and everything that he needed to do. There was no supervisor looking after his work. He will just go in, do his work, invoice the company, and then get paid. And there was no sort of, he knew from the outset, and the company knew, that he was not entitled to any benefits under Employment Standards Act. He will have to negotiate his own vacation and time off and whatnot. So he was in his understanding, he had the impression that he was an independent contractor. But and he approached me for some other employment matter, but as I was interviewing him and I explored more about the nature of his employment relationship, I understood that it was not really an independent contractor, but a dependent contractor relationship. And on the basis of that determination, we were able to get him a significant amount of severance because he was a long service contractor, dependent contractor for that company. So understanding the difference between these categories is essential. It's important, especially if you are terminated and you may not understand the kind of rights you may be entitled to, or you make the assumption that you are an independent contractor and therefore not entitled to any of the rights under termination notice, for instance. So very important to make that distinction. In the next lecture, how do you know whether you are an employee, whether you are an independent contractor or a dependent contractor? We'll talk about it. And who decides? Is the employer that decides whether the nature of relationship is an employer-employee relationship? Is it you, the employee, or the contractor who decides the nature of that relationship? Is it Canada Revenue Agency? Canada Revenue Agency has quite significant stakes in the definition of how the nature of relationship is defined, because on that basis they will get their taxes. And finally, whether it's the courts that decide upon the nature of your relationship. And the answer is really it's one and all. Each one of them has a role, has some stake, has some rights in deciding the kind of relationship you are in, but ultimately it's the courts that will decide what is the nature of that relationship. And to understand that, please stay tuned for the next lecture. We'll talk about it. And hopefully this basic concept was useful, understandable. If it's not clear, if you have any questions, comments, please contact us. If you require any specific consultation about your issues, you can contact us through Clarity or directly through our firm Formative. Look forward to talking to you in the next lecture. Thank you.